The trap has been set, and the most dangerous part of this specific legal architecture, the detail that is currently generating a state of quiet, controlled panic inside the hallways of the Department of Justice right now, is that Pam Bondi does not yet fully understand the dimensions of what just closed around her. Precisely 24 hours ago, the nonpartisan watchdog organization known as American Oversight filed an emergency court order targeting both the DOJ and the Federal Bureau of Investigation. This isn't a suggestion. This is a high-velocity legal demand for a federal judge to force the immediate release of internal communications. We are talking about the digital paper trail documenting exactly how Bondi suppressed, how she redacted, and how she buried the Jeffrey Epstein files. Understand the gravity of the instrument being used here. This is not a standard Freedom of Information Act request that can be slow-walked for 3 years. This is not a sternly worded congressional letter. This is an emergency court order. In the American legal system, that is the specific weapon you deploy only when you have a good faith belief that evidence is being actively concealed, and when you can argue to a judge that any further delay constitutes irreparable harm to the public interest. American Oversight is telling a federal judge in no uncertain terms that the Department of Justice is hiding something so significant, so time-sensitive, and so directly relevant to an upcoming sworn congressional deposition that normal legal timelines are no longer sufficient to protect the integrity of the law. And the judge being asked to step in, that judge has the unilateral authority to kick down every digital door in the Justice Department, to bypass the bureaucrats, and to hand Pam Bondi's own private emails directly to the very people who will be questioning her under oath next month. Here is what the data shows us. Only days before this emergency filing was triggered, the Department of Justice made a claim that legal observers across the entire political spectrum are now describing with a mixture of pure disbelief and absolute outrage. The DOJ stated on the record that they had, and I am quoting the filing here, no responsive records regarding their internal Epstein file review process. Think about that. No responsive records from the United States Department of Justice regarding an internal review of the most politically explosive document cache in modern American history. This is a review that senior DOJ officials have already publicly discussed, a review that congressional investigators have documented through hours of testimony and piles of correspondence, and a review that produced the heavily redacted partial disclosures that triggered the impeachment articles now filed against the Attorney General herself. The DOJ looked at a legal demand for the documentation of how they handled the Epstein files, and they responded with 3 words that American Oversight has now taken as a direct challenge to a federal judge: no responsive records. That claim is not a legal defense. It is a detonator. And American Oversight just lit the fuse. Consider what that no responsive records claim actually represents in this specific legal context. The mainstream coverage is treating this like standard bureaucratic stonewalling, but it is something far more legally consequential. Under federal law, agencies are strictly required to conduct good faith searches for responsive documents when they are subject to legal demands. The legal standard for a good faith search is not met by a search designed specifically to avoid finding what everyone knows exists. When an agency makes a no responsive records claim in the middle of a legal proceeding, that claim becomes a sworn representation. It is a documented statement that, if contradicted by the contents of the agency's own files, transforms instantly from a defense into primary evidence of obstruction. American Oversight isn't just complaining about a slow search. They are arguing to a federal judge that the no responsive records claim is demonstrably false, and they are asking that judge to compel the production of the very documents that would prove the lie. The timing here is the strategic element that transforms this from a dry legal action into a weapon of devastating precision. The people inside the DOJ who actually understand federal discovery practice are the ones experiencing the most acute anxiety right now about what happens next. Pam Bondi's congressional deposition is scheduled for next month. If this emergency court order is granted, it would place her internal emails, the communications documenting how she personally directed, reviewed, and authorized the suppression of the Epstein files, directly into the hands of her questioners before she sits in that chair, before she places her hand on a Bible, and before she answers the very first question. Lawmakers would be holding Bondi's own words, her own documented communications describing the decisions she made, while she is simultaneously required to testify under oath about those exact same decisions. That sequencing is not an accident. It is the architecture of a perjury trap built by people who understand exactly how to construct one. To appreciate why the internal response to this filing is being described by sources as institutional paralysis, you have to understand the concept of a perjury trap in its purest form. It isn't just a situation where someone might lie. It is a situation where the documentary evidence contradicting a potential lie already exists, has already been preserved, and will be in the possession of the questioners before the testimony even begins. In a typical congressional deposition, witnesses can manage their testimony. They can control what they acknowledge knowing, they can characterize their role in the decisions under scrutiny. But that management capacity depends entirely on the questioners not having access to the witness's own private communications. The moment those communications are in the hands of the committee before the testimony starts, every single management strategy available to the witness collapses. You cannot claim ignorance of a decision that is documented in an email you sent. You cannot deny involvement in a process that your own communications describe you directing. The emergency court order is designed to eliminate every one of those options before Pam Bondi even walks into that room. Inside her inner circle right now, the calculation being performed is one of the most consequential legal assessments any senior official has faced in this era. The question is no longer just whether the judge grants the order. The question is what the order will produce. And that question has an answer that already exists in the DOJ's own files. An answer known to the people who created those files. Bondi's communications about the Epstein review were generated by real people, sent to real recipients, and archived by government systems that retain records regardless of how politically sensitive the contents might be. Whatever those instructions were, whatever decisions were documented, that content exists, and this emergency court order is the legal instrument specifically designed to extract it from the institutional environment that has been protecting it. The panic inside the Department of Justice is not about what the emails might say in the abstract. It is about what specific people know those emails say in the specific. American Oversight did not file this without a considered assessment of the evidentiary landscape. Watchdog organizations of this caliber do not invoke emergency procedures without a documented basis. In this case, that basis is the upcoming deposition. They are arguing that every single day that passes without the production of Bondi's internal Epstein communications is a day that the integrity of that upcoming sworn testimony is potentially compromised. This argument carries the specific legal weight of a witness protection claim, the claim that evidence relevant to an upcoming proceeding must be preserved and produced before that proceeding occurs. A federal judge evaluating this is not evaluating a political argument. They are evaluating a legal claim about the integrity of the sworn testimony process itself. And that claim, on its documented merits, is significantly stronger than the no responsive records defense it was designed to demolish. The DOJ's internal legal team is now confronting a defensive situation that has no clean resolution. If the judge denies the order, American Oversight appeals. And the record documenting the no responsive records claim becomes part of the permanent public record for congressional investigators building an impeachment case. If the judge grants the order and the DOJ complies, the communications go straight to the people preparing to depose Bondi, and those communications become the foundation of the most devastating questions she will ever face. But there is a third path. If the judge grants the order and the DOJ resists, that resistance itself becomes a new category of constitutional defiance. It layers obstruction of a federal court order on top of a record that already includes allegations of perjury. Every available path leads to exposure. The only variable is the form that exposure takes. The no responsive records claim must be seen as the specific legal act it was. When the agency responsible for enforcing federal records law and for prosecuting false statements makes a claim that is immediately challenged as false in federal court, the institutional damage to the DOJ's credibility is not abstract. It is documented. It is specific. Career DOJ officials, people who have spent their professional lives building cases on the premise that document concealment is prosecutable conduct, are now watching their own institution make a document concealment claim in the most publicly visible context imaginable. The cognitive dissonance is real. The federal judge in this story is the decision maker whose ruling will determine if Bondi walks into that room carrying her undisclosed communications as a hidden liability, or whether those communications are already on the table when she sits down. Federal judges understand these stakes with the same clarity as the parties involved. The legal standard for emergency relief, demonstrating likelihood of success on the merits, irreparable harm, and the public interest, is a standard that American Oversight's filing was built to meet with surgical precision. No responsive records claim is simply not a credible response to a properly documented emergency motion. It is the kind of claim that judges look at with the specific skepticism that comes from understanding what it would actually mean for those records to truly not exist. Congressional investigators are watching this filing with a focused interest that goes beyond general accountability, because the emails this order would compel are not just relevant, they are potentially the most probative evidence available for the perjury charge. That charge carries independent criminal exposure. It requires proving not just that false statements were made, but that they were made knowingly. Internal communications in which Pam Bondi's own words document her knowledge of the Epstein file handling process and her awareness of the legal obligations she was choosing not to meet would transform that perjury charge from a circumstantial conclusion into a case built on direct, documentary proof. That is the difference between a charge that faces a legal challenge and a charge that faces a conviction. The psychological reality inside the DOJ right now is something the public coverage is missing. Career attorneys are processing the possibility that the institution they serve has filed a false representation with a federal court. Political appointees are watching their no-responsive records strategy collapse under the exact legal pressure they were warned it would not survive. And Bondi herself is confronting the isolation of a senior official whose own institutional resources are now actively working against her legal interests. The emails were generated by her institution, archived by her institution, and are now being sought through a legal process that her institution's own false claim has made more credible, not less. What happens in that federal courthouse is the most consequential immediate legal development in the entire Epstein file saga. It is more operationally significant than the impeachment articles in the near term because the outcome will shape the evidentiary landscape of everything that follows. A judge granting this order does more than produce documents. It produces them on a timeline that puts them in the hands of Congress before the testimony. It creates a context where every question must be answered honestly or face the criminal exposure that is already on the table. And it happens as the direct legal consequence of a false claim made to a federal court, a consequence they were warned about and chose to ignore. The trap is almost perfectly constructed. The DOJ walked into it, and a federal judge is about to decide whether to pull the lever that closes it completely. Pam Bondi is facing a legal convergence that standard institutional defenses were never designed to survive. The impeachment articles are filed. The deposition is scheduled. The order is before the judge. The no responsive records claim is on the record. And somewhere in the digital vaults of the DOJ, the emails documenting exactly how she directed the suppression of the Epstein files are sitting, waiting for a federal court to crack them open. She cannot unfiled the claim. She cannot unscheduled the deposition. She cannot unreceive the impeachment charges. And she cannot delete the emails, not without adding evidence destruction to a record that already includes perjury and subpoena defiance. This is the accumulated consequence of every decision to suppress rather than disclose, every maneuver chosen to protect the names in those files at the cost of the legal exposure now surrounding her from every direction. The ruling is coming, the deposition is coming, the emails exist, and the only remaining question is whether all three arrive in the exact sequence that American Oversight designed, with Bondi's own words in the hands of Congress before she ever raises her right hand and swears to tell the truth. The strategic architecture of this perjury trap depends entirely on one factor: the possession of the smoking gun documents before the witness ever speaks a word under oath. Inside the Department of Justice, the panic is no longer theoretical, it is operational. Career attorneys are currently grappling with the reality that the no-responsive records claim, a strategy designed to buy time, has instead accelerated their legal exposure. According to the filing, the DOJ's representation that no records exist regarding the Epstein file review is being challenged not just as a mistake, but as a documented falsehood. If a federal judge finds that these records were intentionally withheld, the DOJ's standing to enforce federal records law evaporates instantly. We are looking at a scenario where the very agency responsible for prosecuting document concealment is caught in an act of document concealment. The specific documents at risk of release include Bondi's internal emails and private digital communications. These are not abstract memos. These are the direct instructions she issued regarding the redaction and suppression of the Epstein files. Under Section 12 of federal discovery rules, a good faith search is a legal requirement. By claiming those records don't exist, the DOJ has effectively backed itself into a corner where any discovery of those files becomes prima facie evidence of obstruction. For Pam Bondi, the isolation is becoming absolute. She is preparing for a congressional deposition next month, while the documents that could impeach her testimony are being extracted by a federal court. The architecture of this trap ensures that she cannot claim a lack of memory or lack of involvement if her own archived words describe her directing the very process she is being questioned about. The legal standard for this emergency relief, demonstrating irreparable harm to the public interest, is precisely what American Oversight is using to skip the standard 3-year waiting period for FOIA requests. They are arguing to the judge that the integrity of the sworn testimony process is at stake. If the judge agrees, the digital vaults will be cracked open within days, not months. This isn't just about a political scandal anymore. It is about the independent criminal exposure associated with the perjury charge. To prove perjury, investigators must show that false statements were made knowingly. Those internal emails are the missing link, the direct documentary proof of her knowledge and intent. The transformation from circumstantial evidence to direct proof is what turns a political headache into a federal conviction. The DOJ's internal legal team is now facing a zero-sum game. If they resist the court order, they add constitutional defiance to their existing problems. If they comply, they hand the prosecution the very weapons needed to dismantle their defense. Every digital archived system, every sent folder, and every redacted line is now a potential liability sitting in the DOJ's own vaults. The trap is set, the fuse is lit, and the sequence is moving exactly as designed.